Thank you very much indeed, Watanabe-san, and thank you very much, Professor Hideaki, for your introductions and for having organized this event. I want to start off by emphasizing something that is perhaps not sufficiently emphasized in relation to ownership, and that is the nature of ownership of the largest companies around the world listed on stock markets around the world. And that feature is that there is a parallel form of ownership that prevails in nearly all countries in some of the most significant listed companies, that they are traded actively on liquid stock markets, but that in most countries, there are also significant holders of substantial blocks of shares that are essentially the controlling shareholders in those large listed companies. And this slide shows the extent to which the three largest shareholders of listed companies in different countries control blocks of shares. And you can see from this that on average around the world, around about 40 to 50% of the shareholdings of a company are on average controlled by the three largest shareholders. But you can also see that there's a considerable variation in that across countries, with at one extreme rising well above 50% and at the other falling below 20%. And within that, by far and away, the largest single block of shares is held by families around the world. Families are the dominant forms of ownership of even the largest listed companies. And there are significant blocks also in the hands of institutional investors, of other companies, of other financial institutions such as banks, and also by the state in some countries. But in the case of the UK, and to a slightly lesser extent in the US, ownership is not that concentrated in the hands of block holders. And in particular, in the case of the UK, it's certainly not concentrated in the hands of families. And that brings out an important feature of what we conventionally look at in terms of nature of ownership, focuses on the Anglo-American case, which is very much the exception rather than the rule in terms of the level of dispersion, and in the case of the UK, the absence of family ownership. Now, in the case of Japan, prior to the Second World War, ownership was very much along the lines of the pattern that I've just been describing, with concentrated holdings in some of the largest companies, predominantly in the hands of families in the form of zaibatsu. But in the post-Second World War period, that changed appreciably to initially something that looked Anglo-American in nature, with very dispersed ownership, but which quickly during the 1960s gave way to what then emerged as being the dominant form of ownership, concentrated ownership, but not in the hands of families, in the hands of banks. And that became the period of the bank ownership of Japanese companies, until its demise during the 1990s, and then the unwinding of the bank holdings at the end of the 1990s and through to the 2000s. And from there, we can see that outside ownership, outside of insiders in the form of either banks or families, began to grow during the 2000s. But it then stabilized, and insider ownership stabilized around 30% on average in the form of cross-shareholdings of companies holding shares in each other. And the system that prevails today is now one that reflects both the presence of those cross-shareholdings and outside shareholders, with an active debate going on in Japan at the moment about reform to promote the role of outside relative to the insider cross-shareholdings. And alongside that has been another feature, and that is the emergence of shareholder activism. And as this slide shows, that from about the early part of the 2000s, there was a rapid rise in activism in Japan, which has continued up until now. Now, what I want to try and do is to really provide an explanation for these features of ownership around the world, in Japan and elsewhere. And to do so, I want to begin by trying to distinguish between a number of concepts. The first one is the notion of the purpose of a company as against its strategy. The second is the shareholding of firms as against ownership of companies. The third is the notion of agency as against trusteeship. And the fourth is activism as against acquisition. In relation to the first of those, the purpose of a company, as has been emphasized in this series of webinars, is very fundamental. It's about the reason why a company exists, why it's created, its reason for being. The strategy of a company is not so much the why question, it's the what question. What does the company do? What does it intend to do? And how does it intend to do it? And the way in which I've discussed the purpose of a company has been in terms of the notion of solving problems that you and I face as individuals, as societies and communities, and as the natural world. And to do so in a form that is commercially viable, financially sustainable, and profitable. And so the way in which I've defined purpose is to produce profitable solutions to problems of people and planet, not profiting from producing problems for either. And what I argue is that that needs to be thought about as being something that is core to a business and is the overarching framework for its strategy. And the way in which I've suggested that that should then link into the governance of companies is through the defining of that purpose, connecting it with the strategy of the business, ensuring that that purpose is really owned by someone in the organization, and that it's linked to the measurement and reward structure and the reporting of the company to outside parties. Now, key to that then is the notion of ownership. And the first point to notice is the notion of shareholding, which is about the holding of a share or the sharing of a holding in a company. Ownership, in contrast, is about possession of something, in this case, possession of a company, and responsibility for the possession of that entity. Based on work that the eminent civil law academic Anthony Honoré wrote about the criteria of ownership, where he set out 11 criteria that are necessary to define the notion of ownership. John Kay, the British economist, then observed that in the case of companies where there are widely held shareholders, as I was describing in the case in particular of the UK and the US, those shareholders basically satisfy none of the conditions that Professor Honoré put forward as being required for ownership, and concluded that shareholders, as they're conventionally thought, are not really then owners of companies at all. So that then obviously raises the question as to, well, if shareholders are not the owners, who are the owners. And in that regard, it's important to distinguish between two concepts of agency and trusteeship. Within the context of a conventional view of the firm, the directors of a company are regarded as the agents of the shareholders, managing the shareholders' assets on their behalf, and they owe a duty, a fiduciary responsibility to the investors in the way in which they manage the shareholders' assets. In contrast, the trustee version of the directors of a company emphasizes the role that the directors perform in terms of managing the assets of the company as a whole, including its financial assets and material assets, but also in the form of its human assets, the way in which it employs natural assets, and its dependency, for example, on its societies. And the directors then essentially have responsibilities which are not just ones of agents of the shareholders, but as trustees of all of the contributing parties to the company in relation to the way in which the company then impacts on all of the parties to which it has relevance, such as its customers, but also its societies and the environment. And that distinction is brought out quite well in the context of UK company law, and in particular, the most relevant part of the UK company law, which describes the director's responsibilities. And there are two ways and two options that the law talks about in terms of viewing those director responsibilities. The first way which it describes is the conventional way in which it's interpreted, which is sometimes described as being enlightened shareholder interest, and that is the director must promote the success of the company for its shareholders, but in so doing, it has to have regard both to the long term and to the impact on other stakeholders. In other words, it should take account of the long term, and it should take account of the interest of other stakeholders, but only insofar as that promotes the interest of shareholders. But there's an alternative that the law sets out, and it suggests that as an alternative, a company can choose to adopt another description of the role of the director, and that is that the director should promote the purpose of the company. So in the context of what I've been describing as the purpose, that alternative approach would talk about the director of a company acting to promote profitable solutions to the problems of people and planet, not profiting from producing problems for either. Now, the importance of that is that within the traditional approach, the view of the director as agents of shareholders means that in the presence of dispersed shareholders, then since the directors are merely agents of those dispersed shareholders, neither the directors nor the shareholders can really be described as being owners of the company in a conventional sense. In that case, there isn't really the notion of ownership at all within a dispersed ownership scheme. In contrast, the purpose approach suggests that the directors of the company are there to act as trustees of the company purpose. And as trustees, they have the types of ownership rights and responsibilities that are associated with a trustee role, in this case, in relation to fulfilling the company's purpose. And that's brought out in terms of thinking of the governance arrangements within a company. In the traditional approach, by being accountable to shareholders for the success of the company, the shareholders have associated rights, and in particular, important rights in relation to the appointment and removal of the directors. In contrast, under the purpose approach, the directors are accountable to all of the parties contributing to the delivery of the company's purpose, and therefore rights of appointment and removal of directors are not necessarily restricted to those of the shareholders, but could apply to any of the parties contributing to the purpose as specified in the company's constitution. Now, to give some examples of how this applies in practice, one can think about this role of the directors in relation to the company as a whole in, for example, the context of a supervisory board approach, a two-tier board, as exists in a number of continental European countries and in various countries around the world, in which a combination of both shareholders and employees are involved in the ultimate oversight of the running of a company. Or one can think about it in terms of a more formal notion of ownership, for example, in terms of employee ownership, or what is regarded as potentially a preferable approach to employee ownership through employee benefit trusts, where in essence there's a trust that oversees the running of the company that acts on behalf of not just current generations of employees, but future generations as well. Or in terms of another trust arrangement, namely where the company is actually owned by a foundation, where that foundation has a charitable purpose, but its primary function is to oversee the running of the company. And in the case of Japan, one can think about that notion of ownership of purpose as having resided during the banking era in the hands of the bank holding companies, and then subsequently in the 21st century in the hands of other companies through those cross-shareholdings. Now, what that brings out is that there are a variety of different forms in which, if one views ownership as being performing that trustee type of function, there are a variety of different owners who can play that role, and indeed the governance structure through, for example, a two-tier board is another way in which that can happen. But this also brings out another point, and that is that while there may be some merits associated with broadening the scope of a purpose of a company beyond just shareholder interests, there are also potential detrimental effects as well. One only has to look at the effects of the bank holdings in Japanese companies at the beginning of the 1990s to recognize some of the defects. We'll be potentially hearing about some of the defects associated with industrial foundations in, for example, the case of ThyssenKrupp later in the seminar, and the cross-shareholdings in Japan that prevail today are the subject of much discussion about low rates of increase of wages in Japan, low levels of productivity, and lack of innovation. So that brings out the notion of the potential benefit of not just having insider owners acting essentially as trustees, but the role of outside shareholders as well. And the importance of that takes a number of different forms. First of all, the significance of the share prices of companies as a source of information on corporate performance, which guides the allocation of resources. The second is in terms of promoting corporate efficiency and the focus on shareholder value as a way of encouraging greater degrees of innovation and efficiency. And the third is obviously the role that capital markets, including equity markets, perform in providing risk capital. And in that regard, activism is a critical element. And it's critical in terms of a number of aspects, and that is in terms of altering both the leadership and the strategy of companies where there's been a failure to promote corporate efficiency in firms, or focus on greater efficiency and shareholder value, and the potential of not simply having engagement of owners through holding large blocks of shares over long periods of time, but having engagement either in the form of activism or private equity that has a rather shorter period of engagement. Now, the question that has arisen in relation to both activism and private equity engagement is whether or not this is essentially a form of wealth creation or wealth transfer, where in the process of improving returns to shareholders, this comes at the expense of other parties. Well, what the combination of a system of outside shareholding with the potential for engagement through activism and long-term ownership in the form of the blocks of shares to which I was referring offers is the potential of doing both. Namely, the ownership of purpose retains that focus on delivering benefits in the form of solving problems to parties beyond the shareholders, whereas activism encourages a focus on efficiency in terms of delivering greater returns to shareholders. Because remember, and this is the key element that underpins this notion, that the purpose of a company has those two components of both solving problems, but also doing so in ways which are profitable. And what one observes if one looks at activism around the world, as Julian will describe, is that the nature of activism differs appreciably, with a focus on what will be termed quiet activism in the case of Japan, where there are insider blocks that need to be persuaded to come on board, not just outside shareholders. And the fact that what we're observing is that there is a shift in the attitude of many activists away from a shorter term intervention of 2 to 4 years to something that extends to 5 years or beyond, as a way of avoiding the possibility of there being wealth transfers at the expense of others. And that furthermore, we're also observing the rise of activist funds that are focusing on objectives that go beyond just shareholder interest. One of the best known examples of that that's emerged recently is the one that Jeff Ubben and Lynn Forrester de Rothschild set up a year or so ago, called the Inclusive Capitalism Fund, which is focused on engagement, which is directed towards promoting more purposeful businesses that focus on solving problems of the world. So what we're beginning to observe in activism, and similar things are beginning to happen in relation to private equity, is a rather different form of engagement from what's been observed to date. But there is also an important distinction between activism and acquisitions, because what acquisitions do is to change not only the strategy of the company within a broad overall purpose, but also through seeking to create synergistic benefits between the acquirer and the acquired company to align the purpose of the target firm with the purpose of the acquiring company. And so there is an important distinction in terms of blocks of shares being purchased by activists and acquisitions of entire companies, which involve a change in purpose, as well as trying to restructure companies to deliver their purposes more efficiently. So what emerges then is the importance of purpose, ownership, and trusteeship in terms of a long-term perspective on problem solving, of avoiding of wealth transfers, and protection of interests of societal and environmental concerns, as well as those of shareholder concerns. Whereas what strategic engagement, shareholders, and agency emphasize is a focus on efficiency and performance, engagement and activism to enhance performance, and combined with the purpose and ownership of trusteeship in the context of avoiding the potential detriments associated with wealth transfers. Now, just finally, to think about this in the context of Japan and who one should be looking to act as the long-term owners, there are a number of parties that could play that role, from domestic institutions such as insurance companies and pension funds within Japan, in the private sector or the public sector, for example, in relation to the Government Pension Investment Fund, GPIF, or it could well come in the form of employee ownership or employee benefit trusts, and potentially in the form of other forms of trusts and foundations. So to conclude, what I've emphasized is the diverse forms of ownership around the world, that the dominance of block holders, even in the largest listed companies, is a feature of stock markets around the world, that block holders are very often in the form of families, but neither in the case of the UK or Japan. In the case of Japan, instead, it has historically taken the form of banks and companies, and one can view the parallel system of block holders around the world in combination with liquid shareholdings as being a combination of delivering efficiency in terms of purpose and strategy, purpose of problem solving and strategies of efficiency, delivery of those. But one shouldn't regard dispersed shareholders really as owners. Ownership of purpose involves an accountability not just to outside shareholders, but to the parties involved in the delivery of the purpose. By so doing, one retains a focus on the long term as well as short term benefits that can be derived and avoidance of wealth transfers. Together with activism that promotes a stronger emphasis on efficiency and performance, then one can combine the benefits in terms of delivering purposes as I've defined it in terms of profitably solving problems. And I've suggested that in the case of Japan, there are several parties who might play that role as being the long-term owners of Japanese companies. Thank you very much.